Hello everyone and welcome to the latest in our series of Dehns webinars. I'm Chris Goddard and I would like to talk to you today about the Supplementary Protection Certificate system in Europe. This is actually the first of two webinars we plan to do on this topic. This first one will be a general introduction for those who haven't met the SPC system before or would like a refresher. And then the second one, which is scheduled for the middle of August, will be a more in-depth look at some of the case law that's currently ongoing at the moment and some of the current grey areas in the system. So, very brief introduction to me. I'm Chris Goddard. I'm a partner at Dehns and I joined the firm about 20 years ago now, in November 99. And I've been lucky enough since then to have worked with medicinal, pharmaceutical, diagnostic clients for the whole of that time, and in fact seen some of them from first few patent applications right through to marketing authorization and application for an SPC. And so it's that final sort of step in the development journey that I would like to talk to you about today. So, a brief outline of what we have planned. First of all, we'll look at the very basics of an SPC, of what the aims are, a few of the underlying laws, how one applies for an SPC and what sort of term of protection might be achievable from that. We'll then have a delve briefly into the European regulation which underpins SPC law, having a look at what a product is, particularly as defined in Article 1, and then at some of the conditions required for obtaining an SPC, and that's set out in Article 3. Finally, we'll briefly touch on the scope of protection that one might hope to achieve. So, starting right at the beginning, an SPC is a patent term restoration right. The thinking behind it is that certain products that will be marketed require a marketing authorization before that can take place, and that takes time, and a patent term is fixed at 20 years, and so if an organisation is having to wait for marketing authorization before they can sell their product, they lose some of that 20 years, and an SPC aims to restore some of that lost protection. So it takes effect immediately after the expiry of a basic patent, of an original patent right, but it's not a patent term extension in the same way that they have in the US, for example. In Europe, an SPC is an independent, a so-called sui generis right, which kicks in the moment the patent expires, but it's somewhat more narrow in terms of its scope of protection than a simple extension of the patent term itself. The scope of SPC protection depends not only on the patent itself, but also on the marketing authorization. And actually, the exact scope of what could be protected is still not quite clear, but that's a topic more for our next discussion in a few weeks' time. The little graph at the bottom here gives us some idea of what we really aim for with an SPC. This is from a good few years ago now, but these were sales of Prozac, of fluoxetine hydrochloride, after its launch. And I appreciate that not every drug is a first-in-class blockbuster, but ideally what we would look for is something like this. So you can see Eli Lilly launched this, Prozac about 4 years before the end of the patent term. And they had some sales during that period, but sales revenue really started to take off just as they were reaching the end of patent term. However, fortunately, they had 5 years of SPC coverage, and you can see that's the area in yellow on the graph there, that the revenue protection provided by the period of SPC coverage is some considerable multiple of that provided by what was left of the patent. And so really this is why SPC coverage can be so valuable to companies and why they're prepared to push and stretch and test the regulations as far as they can, and we'll see a little bit of that as we go on. So, some of the laws behind SPCs. Really the only key one that you need for the pharmaceutical and veterinary products at least is the first one listed on this slide. The EU regulation underpins everything. The reason that I put up this slide is that Although it's a regulation that has direct effect, the law should be unified more or less. SPCs are national rights, which means that national patent offices, national courts all get a say in how that regulation is interpreted. And that's led to a considerable lack of harmony in the implementation of an SPC, even though it's governed by essentially a single rule. SPCs are also applicable to other products that require marketing authorization, particularly plant protection products. There's a corresponding regulation for those, and I'll make sure that that is circulated with the email that comes out to you after this presentation, because that should have been on the slide. I will talk primarily about the pharmaceutical and veterinary regulation, but even down to some of the article numbers, the plant protection regulation is very much the same. The reason I put this up really is to show you that there's lots of laws that have a take on this. It's covered by EU law from this regulation. It also covers the European Free Trade Area, so-called EFTA. So some additional national laws and so forth get a bite at it from that. And so there are all sorts of laws pulling in all sorts of directions as well. One thing that's pretty certain, however, is how we go about applying for an SPC. And that is that it needs to be applied in a national patent office. So for example, at the UK Intellectual Property Office for a UK SPC. And the period for application is a 6-month window starting from the later of the grant of marketing authorization or the grant of the patent. So there's 2 timelines on the slide. In the top one, you can see the patent grant before the marketing authorization. So we have a 6-month period for SPC application beginning at marketing authorization grant. The second timeline on the bottom, marketing authorization occurs first, patent grants afterwards. So that patent grant is then the trigger for this 6-month window. And one thing I would say is that those of you using external counsel for your patent applications, please keep them in the loop about the marketing authorization, because you can imagine if the marketing authorization is governing this 6-month period, you need to know that. So do keep your patent attorneys in the loop. So what sort of period of protection might we get from our SPC? Well, the underlying principle behind it is to try to top the period of protection up to 15 years from marketing authorization. You can't begin to sell till marketing authorization, so the idea is to give you 15 years of protection after that. So it's capped out at 15 years, but the amount which the SPC can contribute to that 15 years is a maximum of 5. So in the event that you have 10 years or more of patent protection remaining, that will be topped up to 15. If you have a smaller period of patent remaining, you get your full 5 of SPC, but that won't take you to quite the 15. So you can see again a timeline in this slide. In this case, the marketing authorization occurred 8 years after patent application, which gives 12 years of patent term remaining. That then is topped up to 15 with 3 years of SPC. If it had been the other way around, and it had taken 12 years for marketing authorization, leaving 8 years of patent remaining, you would then get 5 years full SPC, which would take that 8 up to 13. So maximum of 5 years of SPC, or a maximum of 15 years protection following marketing authorization. Just one little illustration of how hard companies are prepared to push their SPCs to try to get just a marginal addition in their protection is the Seattle Genetics case that's referred to at the bottom of that. And that's a fairly recent case which decided that actually one can take the date of notification of the marketing authorization for that start of 15 years rather than the date actually stamped on the authorization itself. A difference in that can be a few days at most, but that pushes your 15 years to a few days later, and that gives you a few days extra protection. And it was worth taking the case all the way up to the CJEU in order to secure those few days. So we'll take a little delve into the EU regulation. And in this slide, I'm just going to highlight a few definitions which are important as we go through. So Article 1 holds these definitions, and the most straightforward definition is in 1A, which is a medicinal product. That's really what you might think of as a medicinal product. And pleasingly, it covers things like diagnosis, restoration and modification of functions, rather than just correcting. So there isn't too much of an issue as to whether a diagnostic medicinal agent or something like a lifestyle medicine would be covered by an SPC. They should all fall under this medicinal product definition. However, Part B defines a product, and that is not what one would perhaps think of from straightforward use of the language, because product is not the thing that you sell as far as the EU regulation is concerned. The product is the active ingredient or the specific combination of active ingredients. So we're right through the regulation, where we say product, we don't mean the thing that's bought and sold. We don't mean the formulation, we mean the active agent or a combination of actives. And how far one can push that is the subject of some of the current case law, which we will look at next time. But fundamentally, product means active agent or combination. And throughout, you'll see the term basic patent. Basic patent is the existing patent protection. It needs to cover the product, and this is the thing that we're intending to extend. So, products eligible for SPC protection? Well, medicinal or plant protection products. So those include veterinary products and, as we say, include things like diagnostic and modifying, correcting type agents. The product is the combination or the active agent or the combination, and each of those active agents to count as such needs to have a therapeutic effect of its own. And you'll see a few cases highlighted in these slides. I don't really intend to talk about the cases, they're just there for your reference if you would like to look into detail. So the active agent, according to the MIT case, needs to have some sort of therapeutic effect on its own. So for example, a vaccine adjuvant cannot form the basis of an SPC in itself because it's not considered to have an activity of its own right. It may have a very significant adjuvant activity on the effectiveness of a vaccine agent, but that's not enough. It doesn't count as an active agent, and it doesn't count as a combination of actives because it has no therapeutic effect in its own right. Also, medical devices are not generally protected. So, for example, a stent counts as a medical device, and even if that's coated with something like paclitaxel, which has an extremely, obviously an extremely high therapeutic effect of its own, paclitaxel stent can't be covered by an SPC because it's fundamentally a medical device. And one thing to consider, and we'll look at that slightly further, is the fact that one can protect our product with our basic patent in essentially any form of patent protection. So we can cover the product itself, its method of manufacture, or the use of that product in a second medical use type claim. But where it gets to that, things become a bit complicated, and again, we'll look at that a bit further in a minute. So Article 3 will perhaps be more of the substance of what we need to look at, and that talks about what you need in order to obtain SPC. So we're going to need a patent which protects our product, remembering that the product is the active or the combination. We're going to need a valid authorization, and that is something that we'll see has been tested recently. And parts C and D of this limit the situations we can have an SPC. So the product, again the active agent, must not have been the subject of a previous SPC certificate. And the authorization that we're relying on needs to be the first authorization, again for the product, to place that on the market. And those we'll elaborate on slightly in a moment. So what do we mean by protected by basic patent? Well, the patent can be a European patent or it can be a national patent. So for example, UK designation of a European application or a direct UK application. The patent needs to be owned by the SPC applicant, and needs to be enforced in the relevant country. So just having had the EPO grant a patent in UK, France and Germany doesn't allow you to secure SPC protection in Italy. You need to have the patent validated in that country. And any of these relevant claims, as I was saying, will apply, so we can cover the active agent, cover a manufacturing process, providing it will obtain that active agent, and we can cover medicinal use type claims, so second and further medical use claims, which these days are the EPC 2000 style of compound X for use in treatment of disease Y, that type of claim style. If that second medical use claim is there simply because there's some academic publication or something of this sort which prevented the active agent being claimed in its own right, then we don't have any trouble as far as SPC protection is concerned. However, if we're using that second medical use type claim because there is a previously marketed product with that same medicinal, the same active agent, same API, then we're into sort of issues here as to whether we have the first marketing authorization or whether there might have been a previous SPC. And again, there's a lot of spatting going on at the moment at the CJU about where this applies and where it doesn't. And we'll look at that briefly and elaborate on that in a minute. So, the product needs to be protected by the basic patent. So perhaps obviously the product must fall within the scope of the claims of the patent. It's perhaps what one would assume protected by meant from a straightforward patenting point of view. But that's actually not enough. So Yada tells us that we need that, but much further, the active agent needs to be specified in the wording of the claims, according to Medeva. And in fact, I seem to have a not quite up-to-date version of this slide because this should also refer to the more recent Teva case, which said that for a combination of actives, both of those actives needs to be identifiable within the invention set out in the patent. And also, in fact, that the use of the combination together needs to be identifiable within the invention. So in this table, you'll see a few possibilities. If we have a patent disclosing and claiming agent A, and the product contains only agent A, yes, it's entirely possible we should be able to get an SPC. We will, of course, have to have agent A being part of the invention, so it can't simply be an accidental disclosure as far as current law seems to be going. It needs to be reasonably identifiable within the patent, but as long as it's identifiable within the patent, then discloses A, product is A, yes, we can have an SPC. Same with the combination, A and B disclosed in combination, product contains the two, yes, we can have an SPC to those two. Slightly more complicated comes if the patent discloses A and B in combination only. Well, our product would not then fall within the scope of the claims because agent A alone will not fall within a claim which requires the presence of a combination of agents A and B. So there, no SPC is possible. And then we get to the most sort of questionable column, which is, well, what if we disclose only A and we have a combination of A and B in our product? Well, this is a situation in which it's very important to consider carefully and take good advice on what it is you're going to apply for. Because you could have an SPC to product A, and it's entirely possible that that SPC may give you some protection for the combination product of A and B together. But you are not likely to be able to get the SPC directed to the combination unless that combination of A and B together is disclosed as part of the invention in the patent application when it was filed. So particularly take care with combination products, and yes, in the event that you have a combination product and the patent only covers one of those agents, think very carefully about what scope you're going to apply for in the SPC, because you could get caught out. So we need a valid marketing authorization to place the product on the market. Well, We won't be selling it, I suppose, if we don't have that. And that needs to be for the country where the SPC is sought. And that can be granted by a national authority, or it can be granted by something like the European Medicines Agency. There will be a slight change to this after Brexit because a UK authorisation will be required, but that shouldn't be too much of a hurdle. So the marketing authorisation needs to be for a product that includes the relevant active ingredient, but unlike the question of patent protection, because we're not talking about a claim and the scope of protection of that and so forth, we're talking about just the marketing authorisation itself. We can have an SPC directed to agent X and have the marketing authorisation to be X for use in combination with Y and Z, and we can still get the SPC towards X based on that marketing authorisation. And so it is potentially possible to get some protection for that product simply by relying on the SPC for X. But if you apply for an SPC for X, Y, and Z together, that might have some trouble. One key point that I touched on briefly earlier is that the marketing authorisation must be in place before the application of an SPC. And Merck were in a very unfortunate situation recently with this, where they were aware that patent protection was about to expire, but the marketing authorisation, although inevitably was about to be achieved, was not in fact granted quite by the expiry of the patent. So they filed the SPC application within the last few days of the patent term, so that the patent would still be valid. And it went all the way up to the CJU, who said, "No, I'm sorry, you have to have your marketing authorisation in place." So a situation here where, in fact, the SPC would have been extremely valuable because it could have provided some protection where the patent would have provided none, but unfortunately Merck were not able to achieve that SPC because the marketing authorisation and the patent didn't overlap for any period of time when they could have put that SPC application in. So we've had a look at some of the conditions for granting SPCs. One of the limitations on this is that the product, being the combination of actives or individual active, should not have been subject to the previous SPC. So the active ingredient needs to be the subject matter of the invention. So what about the situation where we have more than one active agent disclosed in the same patent application? Could one application have more than one product as the subject of its invention? Well, it does appear that that can be the case. So SPCs arising from a combination product can potentially coexist from the same patent application with an SPC on a single product, providing all of the compounds, all of the combinations are seen as part of the original invention when it was filed. So there's two potential situations here with these little balls at the bottom of the slide. In the first case, we just have a patent to compound A. Well, the SPC will be to compound A. We don't disclose B, so obviously we can't claim an SPC to that. And similarly, we might get protection for the A and B combination product from the SPC to A, but we won't be able to get an SPC directed to the combination. Slightly different situation on the right-hand side, we have a patent disclosing A and B. Well, potentially, if both of those are disclosed as part of the invention, both achieve marketing authorizations, we could, in theory, get an SPC to A and a separate SPC to B. And those could coexist out of the same patent. The question then arises, well, what about A and B together? Well, yes, again, potentially we could get an SPC to the combination, but that would need to have been disclosed in combination as part of the invention when the patent was filed, and potentially also in the claims of the patent. So if you do have the possibility of marketing a combination product, try to get those combinations firstly disclosed in your draft when you are having it drafted, and secondly present in the claim set if you can, because the case law seems to be moving more towards what was disclosed in the whole of the invention. but it would still be very wise, because the older case law looks towards that, to have the combination present in the claims if you possibly can. So our marketing authorization that we're relying on for our SPC needs to be the first to place the product on the market. Well, what's the market? The market is the European Economic Area. I think that will then be the EEA plus the UK once we get to the end of the transition period. And well, what is the first marketing authorization? On the face of it, that appears to be the first for any medicinal product. But that's currently the subject of quite a lot of conflicting case law. And that's one of the key things that we'll look at in the next session. And there is an ongoing case on that. We'll have to see whether the final decision on that has come out by the time we have our next session. But just something to be aware of, that the question of what is the first marketing authorization, whether one could get protection for a new indication, whether one could get protection for a product for its first use in humans when it's previously been used in a veterinary situation, all of those questions are potentially up in the air at the moment, and we'll look at the progress on that next time. So, we've achieved grant of our SPC. What kind of protection can we hope to get from this? Well, first of all, the protection is limited by the scope of the basic patent, of the patent which covered the product, or which we are extending by the SPC. So, within the limits of the basic patent, we then get that the protection conferred by the certificate shall extend only to the product covered by the authorizations to place the product on the market. So if you have an SPC to the compound, you couldn't, for example, stop someone using it for a completely different use. Even though the patent might have prevented that, the SPC would only be relevant for uses that were covered by the marketing authorization. Article 5 of the regulation then tells us that the certificate will confer the same rights and give us the same limitations and obligations as the patent did. So we essentially have patent rights to enforce, but there is one recent limitation to that, which relates to the question of manufacture for export. So within the SPC period, there is a slight cutout which was introduced just last year, where if you're manufacturing, then you can potentially do things during the SPC period that you couldn't do during the patent. And there is a recital to the regulation which says that the protection will be strictly confined to the authorized product, which pretty much covered already. However, having said that this is going to be extremely strictly confined, there are a few cases, particularly for small molecules, which suggest that the SPC could cover some slight trivial variants. So if, for example, the licensed product is going to be perhaps the sodium salt, if a competitor produces the potassium salt, unless there is likely to be some significant difference in effect between those two, then trivial salts or esters are likely to be covered according to the Pharma Acts. What's a little more complicated is the question of biological molecules, where variants tend to be slightly less trivial, and that again is something that's a little more complicated, and we will perhaps, if we have time, look at in the next session. So, to round up some of our take-home messages on SPCs, well, the purpose of an SPC is to protect a medicinal or a plant protection product during some of the period that it might have lost patent coverage due to achieving marketing authorization. For pharmaceuticals particularly, it's based on the active agent there, and one must apply within 6 months of a letter of marketing authorization or patent grant. We can get up to 5 years of additional protection from our SPC, but we can't take that above 15 years following marketing authorization, or in fact following notification of marketing authorization. We can only have one SPC per product, which is to say per active agent, but we have the potential for additional SPCs if we have combinations of active agents where those are inventive and disclosed in the patent that we are trying to extend. So the scope of SPC protection will correspond largely to the patent, but is limited to that protection and further limited by the marketing authorization. However, we might allow, particularly for small molecules, some trivial variation in that. And the final additional message that I would say is that SPC law is always changing. And so if you would like to stay up to date, there are almost inevitably European CJU referrals on SPC case law. And so the link to the Curious site that holds those, you can have a look at that for your interest if you would like. That will be clickable through the slides or will be sent round following this talk. Similarly, if you want to have a look at Dehns.com, particularly there's our Inspired Thinking subsite, we'll try to keep you up to date on what's going on in the SPC world. So finally, if anyone has any questions to ask, there is a Q&A box, which I should really have encouraged you to use throughout the presentation. But if anyone would like to ask any questions, there's an opportunity to type those into the Q&A box that you should have as part of your Zoom screen. So give me a moment to have a look for the Q&A box. Good, so we have one already. So that says, oh, that I mentioned manufacturing and as a limitation for, yes, as a limitation for coverage of the SPC. Yes, so I should perhaps have elaborated on that. And in fact, I will try to send round the version of the slides that has a slide update on that. This is clearly not the version I had intended to present on. But they're just last summer, July of 2019, the EU introduced what's known as a manufacturing waiver. And so that does mean that during the SPC period, there are certain acts which can be done without infringing the SPC, which would have infringed the patent as originally granted. But those only apply under a fairly strict, limited set of circumstances, where these relate to manufacture, and particularly where they relate to manufacture for export. So one can make an API, or one can import an API and manufacture that into a final product, providing that final product is destined for export outside of the EU. And the thinking behind this is that, well, the EU has the SPC regulation. This extends coverage, but there are other countries which have significant pharmaceutical manufacturing which don't have corresponding patent term restoration, where generics manufacturers can get a head start by starting to manufacture and can sell into their own market, even though they can't sell into the EU. And so the idea is to rectify that slightly by giving generics an opportunity to work in the EU, providing they're selling into markets where there isn't SPC protection or anything that corresponds. So the SPC now has a cutout which says that if you're making a product for export, or in fact, if you are storing a product within the last few months of the SPC prior to its expiry, then you can do some of those things without infringing the SPC, even though they would otherwise have infringed the patent. And again, we can include a link to the modification of the regulation which talks about that in the email that comes around after this talk. We do have one other which says, what impact will Brexit have on SPCs and the application process? Well, yes, I had a couple of brief references to that in the slide pack. And in fact, the answer is not too much. The process will be exactly the same. And reassuringly, if you have an SPC, if you have an existing application for an SPC, none of those are affected. As I imagine most people are aware, the transition period is currently ongoing, so we have, strictly speaking, left the EU, but we're still sort of operating within it. That will come to an end at New Year as things currently stand. So as of New Year, there will be a small change in that UK marketing authorisations will be required for the application to apply for an SPC. And in fact, existing SPC applications may have to show that they have converted their European marketing authorisations to UK marketing authorisations. But there will be a period set for that, and that conversion shouldn't be an onerous task. So existing applicants should be okay, and new applications, it will be the same process, and the protection should be the same as it would have been previously, because as I say, it's a national right in any case, so it's largely governed by the national procedure. So the UK IPO will continue to operate the same procedure, and the SPC regulation has been incorporated into UK law already. The one thing that was not incorporated is in fact the manufacturing waiver that I was just talking about, because that didn't occur until the summer, until June or July of last year, and the modification to the patent law took place in April. So the manufacturing waiver isn't currently part of post-Brexit UK law, and I think there's a consultation ongoing at the moment regarding that. So do we have any more? A final one asking about second medical indications. Well, really, second medical indications are a whole can of worms in themselves, and I will look at that next time. There are some conflicting cases on that at the moment. One from 2011 with Neurin, which was appearing to really, it was seen as a landmark case and really broadened the application of the SPC system. However, that's being clawed back more recently. So Abraxis was a subsequent case which really managed to distinguish over Neurin, but really I don't quite know how, and didn't in any way endorse that. And it does appear that CJE was clawing back the ground that was given by Neurin, and that probably SPCs are going to be applied much more strictly going forward. But there's an ongoing decision at the moment in Santen, and that we have an Advocate General's opinion at the moment. We don't have the final decision. With any luck, that decision will be out by August, and so we'll know a bit more. So at the moment, second medical use protection, bit of a complicated subject. We'll look at it more next time, but hopefully within the next few months that may resolve itself to some extent. I hope that answers the questions that we have. I don't have any more on screen. So that just leaves me to say that our next webinar is by Tim, who will be talking about the patentability of software inventions, and that will be on the 2nd of July. So please, if you're interested in patentability of software in any shape or form, Tim will take you through that. I will also draw your attention to the IP podcast, which is available from all good podcast suppliers. Search for Dehns and you should find that. Past webinars and podcasts and so forth can also be found on the Inspired Thinking subsection of the Dehns website. So thank you very much for your attention. Michelle has been lurking in the background. I think she will let us know if there's anything more that we need at this point. Otherwise, I will say thank you very much for your attention.
Hi everyone, I'm Michelle, the Business Development Manager at Dehns. Thanks for attending our first webinar on SPCs, and thank you, Chris, for presenting. Chris is going to be hosting part 2 of the SPC series on the 13th of August, so do sign up for that one for a continuation of today's content. I'll send out the details and registration links to all our upcoming webinars in the follow-up email to this. As Chris kindly mentioned, we do have a new podcast series called the IP Podcast, and this is 15-minute bite-sized episodes on the IP process and topical IP issues. So definitely take a look at that if you think it might be of interest. But other than that, I think we can stop there for today. If you have any questions for Chris or topics you'd like us to cover in any future webinars, please get in touch. Otherwise, I hope we can welcome you to another webinar soon, possibly Chris's on the 13th of August. But thanks very much and take care, everyone.
Thank you.